official papers from IRS, but we are a 501c3 once we get those papers. And this was started by Paul back in 2014, and we've been working since 2014. We've been doing these workshops, these asylum workshops, to help incoming asylum seekers file their very complicated I-589s. We've been going through many years. First, we were in Catholic Charities, then we moved to Raíces, and then with the COVID and with the administration, we've moved to work remotely, and now we are reviving it because we had to stop altogether, and now we're reviving it again, moving to Otis when we can, but we're doing it more or less in a virtual sense, the most we can, and one-on-one. So it will be a little bit different, but it will still be very much the same, trying to help asylum seekers. And with that, Paul can tell you a little bit about him, but you can go on ahead.
The start of the show.
You're mute. Paul, you're mute.
Hopeless. Okay, it is 6:30 hour, so let's just I'll launch. We'll get the presentation on, hopefully, to share in a moment. The Pro Se Asylum Clinic started in 2014 when there was a surge of so-called arrivals of asylum seekers from Central America, most of whom were children. The demographic shifted to families, and but the flow continued for reasons that we'll go into in the slides, but boil down to really awful violence in Central America. What was happening, but initially, was just in my small practice, I was seeing lots and lots of prospective asylum seekers who either lacked the resources or for reasons having nothing to do with like the actual degree of danger in their country, were not likely to prevail in applications for asylum. But I had learned years earlier, indeed decades earlier, that sometimes in an immigration court, you can come mighty close to winning your case simply by losing slowly. While applications for asylum are pending, folks can't be removed. And so it was breaking my heart seeing all these folks walk out of my office who I knew had reason to apply for asylum, even if they lacked the resources to hire me or a claim which fit the neat, tidy categories that entitle someone to asylum in this country. In effect, a lot of these youngsters and families were leaving my office without a lawyer because, yeah, they might die, but it wouldn't be for the right reason. And so this troubled me, and I called upon an experience I had years and years, again, decades earlier, with an agency called Proyecto Adelante, and a fellow who became my friend and mentor, Parker Wilson. This was an agency that grew up during the Civil War in El Salvador, representing Central American asylum seekers in another time of conflict. And the agency I saw was able to leverage its tiny staff. I was on that staff for 5 years and saw how it leveraged the staff with volunteers. Throughout those years, the work that volunteers was asked to do did not include asylum. It was thought that asylum applications were too complex, and some of my colleagues still insist that that's the case. And it is because of the concern that perhaps people might not do this application properly and cause even perhaps more harm than good. I developed this training, and we came up with protocols to see that the applications for asylum filled out by volunteers for those who ultimately would not have lawyers, but would have at least a well-prepared application for asylum. The training, tonight's training, and the support that you'll receive from Otis in the weeks and months to come, if you take on this challenge, that this is sufficient to see that that the applications for asylum are in fact at least as good as most of my colleagues, or indeed I would prepare, because you will have the you'll have the knowledge and the supervision to do justice to these refugees' stories. So it was the program started in 2014, grew in number. We ended up filing, gosh and golly, Anna, what was the
About, when the last time I took that into consideration, it was about 350, 300, and then I stopped, but we went on for about another year, so I would say about 500. Okay. Probably.
If you think of that, if you think of the value of the, there's lots of ways to think about the miracle of 350 applications for asylum filed for free. But one is, just hang a price tag on it. In my office for that, there's more that I would do for a client when I charge them $7,500. But that's a good deal of it. That's probably half the work, a properly prepared application for asylum. So, do the math, 350 applications for asylum provided to folks for free when who would otherwise have together paid, what is that, $10,000? I don't know what the math is, not my forte. At any rate, it's a lot. It's a lot. This agent, this newly this organization that is about to become a 501c3 or for a nonprofit organization, has done a lot of good in these past years, and I'm delighted to hear that y'all have revitalized it after a period of dormancy. So I will be, unfortunately, my engagement is going to be largely limited to this training. I'm also happy to serve as a resource as issues come up, but yeah, mostly I'm going to watch from afar and marvel at what at the miracles y'all are pulling off.
Okay. Do you want to start the training now, or do you want to?
If we can get the split, the training up, if I can start.
Yeah, Jackie is here already, so.
Please, okay. Am I enabled? I was not earlier. Am I enabled now to share my screen?
I just made you host, so you should be.
Okay, swell. I'm gonna turn off my video for a moment, just because I'm not hiding anything. I just don't want to fumble. So video comes down. I have two things that I want to share, and I want to make sure that the right one is up for, never mind. Let's just do this. I can do this without there. Okay. Slideshow. I apologize for being so inept. From slideshow, are folks seeing now the presentation? Oh yeah, okay. Thank you for the thumbs up. All right. So the program that began in 2014, as I say, was a response to this perception that that hundreds of potential applicants for asylum in Dallas were not only going without representation, but very likely were not going to file applications for asylum, because as you'll see, the application process is extremely difficult. It's not user friendly. and the judges who accept applications for asylum from those who've been determined to have a credible fear of persecution and avoided thereby expedited removal, the judges don't provide instruction that's worth a darn. So a whole lot of people with who many of whom are scarcely literate are unable to file applications at all. And this troubled me, and hence this clinic. Why are so many people seeking asylum? Well, the Northern Triangle in Central America is one of the most violent regions on planet Earth. The homicide rate in, for a period of time quite recently, the homicide rate in El Salvador and Honduras, between the two countries, they would swap turns annually for the highest per capita murder rate on Earth in countries that aren't actually at war. The reason for this violence primarily is the metastasizing of gangs throughout their societies. There's all kinds of reasons having to do with the disruption of war and crushing poverty, and now climate change. But the gangs in Honduras, El Salvador, and Guatemala are terrifying. I still often find myself tearing up as people describe the atrocities that have been committed against members of their family or against themselves, and committed with impunity, because the gangs in many parts of these countries outnumber and outgun the law enforcement officials. Many times, folks have said to me that when they went to the police in attempting to report crime, they were turned away either by a cop who was too afraid, or more often by a cop who said, "Look, you don't want to do this because, well, whoever did this to you, whoever did this to your mother, your father, your uncle, somehow they learn. They'll find out. I won't be the one to tell them, but they will find out." So, Mr. Martinez, you sure want to make this report? And the answer is very often no. And those who do report crimes to the police very often find themselves punished for it. The other pattern of violence in Central America, sadly, tragically, is women who have been made victims of domestic violence have little or no recourse in the courts and with the police. The police in countries where violent crime is so widespread, there's a perception, unfortunately, that among the police that they have bigger fish to fry, and they simply are very often of no use when it comes to interceding and protecting women from their violent spouses, or companions or former companions. The murder rate among women throughout Central America, throughout specifically these three countries in Central America, is shocking, and perpetrators really do enjoy impunity. So we are needed because the grant rate, asylum grant rate, is crazy low. Those who do find someone to help them with the English language application for asylum, very seldom find someone like us who have the the familiarity with the requirements for a grant of asylum, to prepare their application to tell their story in a fashion that does them any good at all. You'll come to soon to recognize that asylum is a very very peculiar doctrine. It's there are many terms of what lawyers would call terms of art. Persecution is defined, and refugee is very narrowly defined, so that much of the violence that that an applicant for asylum would consider very compelling indeed is simply not relevant. I had an instance just in the last couple of days in my office, a client who was facing violence from both her ex-companion and his wife, and it bothered her more that his wife was threatening. She was more frightened of the wife, and it was with good reason, but for reasons that we'll visit. Sorry for all these teasers, but we'll soon discuss how in asylum law the motivation for the persecution is critical, and the wife's motivation was not going to satisfy the definition of refugee, and unless we could push her to the wings and focus instead on the ex-companion, she was going to be summarily denied asylum. And again, most applications for asylum are folks who are prepared by folks who have the first idea of what it is that actually, what aspects of the story are actually relevant and could merit a grant of asylum. So volunteers, if you step in to lend a hand, it's very important that you follow certain rules. The first of these and most important is confidentiality. The first aspect of confidentiality is perhaps obvious. Don't share the names with anyone, the names of the folks that you help, nor should you share any information that taken in the aggregate might allow someone to recognize an individual. You don't even come close. But beyond this, there is also something that comes closer to a courtesy than to a professional obligation. Even if you leave names out altogether, even if there's absolutely no identifying information, when you're told someone's story about about their assault or their rape or what they've seen that traumatized them, you didn't hear that story. They didn't share it with you for entertainment purposes. To share it with someone at a bar that night is just is wildly, well, it's inappropriate. And I ask you to think about the level of trust shown by the person who shared with you their story of heartbreak, and you treat their trust with that you cherish it as you should. These stories are not for your entertainment or anyone else's. You are not to take this training and the work that you do with the clinic and go and set up shop. Okay, the work that we are doing in this clinic is, if it were not done under the supervision of a lawyer or an accredited representative that is accredited by the Justice Department, it would be unauthorized practice of law. And please don't mistake this training for an all-purpose something that you can take and that would allow you to prepare applications of any sort on your own. This training, though I hope lengthy enough for the purpose of preparing you to work under the supervision of a lawyer or accredited representative in the preparation specifically of an asylum application, it's not it's useful only for this, not beyond that scope. And indeed, if you were to start filling out forms on your own, it would be illegal. So don't, please. And it was irresponsible. Attorney volunteers, if there are attorneys in the audience, you can do this. The Texas Disciplinary Rules of Professional Conduct allow you to help someone who will ultimately proceed pro se. There was a short period of time early in the Trump administration when this was challenged, recognizing that they might maximize the number of folks who don't have the help of lawyers. There was a push to enforce strictly a regulation that seems to say that an attorney should not step in and help someone and only to step out again. A regulation that purports to say that you're in for a dime, in for a dollar. So what I'm doing now, for instance, as a Texas licensed attorney would be improper. A federal district court put an end to that nonsense. You can, lawyers, you can help folks on a one-time basis, even if there are cases before the Executive Office for Immigration Review, that division of the Justice Department where the immigration courts are housed. Okay, which leads us to a procedural primer. Please forgive me. I go through this real fast because there's a lot of terrain to cover, and I don't want to go over time. So I want to honor your time commitments beyond this training, and but I want to cover what I think is the essential elements. Asylum procedural primer. Speak up, Ana, Andres. If you see I'm not paying attention to any question feed, any chat items. If you see a hand go up, if you see something that a question that you think is relevant in the moment, don't hesitate to interrupt me. Okay.
Okay.
Please. Okay. Thanks. So we start with the cast of characters in this drama. The Department of Homeland Security is the agency that, the cabinet level agency that houses the three subdivisions with which our aliens, so-called, interact. First, Customs and Border Protection, also known as Border Patrol. Customs and Border Protection is responsible for arresting folks at they do more than this, but in the context of our folks' stories, they are the ones who arrested our folk and commenced against them removal proceedings. Citizenship and Immigration Services is the agency that provides an asylum officer to determine whether an arrestee should be subject to expedited removal or whether that person should instead be allowed to see an immigration judge. Immigration and Customs Enforcement is the agency charged with detaining folks after CBP has arrested them, and also will dispatch an immigration lawyer, and sometimes I'll speak of them as trial attorneys or ICE attorneys, government attorneys. That is the ICE, that's the responsibility of ICE to dispatch a lawyer to try to tell the judge why it is that he should deport our folk. The Office for Refugee Resettlement is a division of the Department of Homeland Security, Department of Health and Human Services, and it is responsible for housing youngsters who arrive unaccompanied. In this clinic, I think that few, if any, participants will have been through the custody of the Office of Refugee Resettlement. Then comes the Executive Office for Immigration Review, or EOR. It is a subdivision of the Justice Department that includes immigration courts and the Board of Immigration Appeals. I should note here that all of the Executive Office for Immigration Review though it goes, though the judges wear black robes and the members of the Board of Immigration Appeals purport to be judges. Some of my colleagues rather naughtily call these judges not immigration judges, but imitation judges. They don't actually have lifetime tenure. They are hired and fired like any other federal employee, like the fellow who audits your taxes. And they are constrained by policies. One of the things that's really been quite dramatic is that even before dramatic changes were made to the interpretation of the Immigration and Nationality Act, before adjustments were made to relevant case law, judges began granting asylum at a much higher rate, basically as soon as the Biden administration commenced. They are very much subject to policy pressures, and so though I do treat them and speak to them with the respect that I would to a district court judge, I also recognize that it ain't that simple. So policy does affect their decisions to a degree that it ought not. Okay, Customs and Border Protection, as I indicate, this is the agency that with which they first came into contact. Our folk will have come into contact with CBP in one of two contexts. One will be they crossed illegally and were arrested soon after. That the days when folks could avoid detection by CBP are virtually over. I would say that in my office is since 2000, it took a couple of years after 2001 to really tighten up the border, but I'd say that since 2005, the percentage of folks who successfully evade capture or evade arrest by ICE or CBP, I'm sorry, is something down to maybe a fraction of 1%. And mostly, with very, very few exceptions, folks actually do look for ICE after having crossed the border, because so much of the border is really quite inhospitable and dangerous. So there's one way that they land in CBP custody. Another is presenting themselves at a port of entry and just declaring that they want to apply for asylum. This will entitle them to very little, actually, but at least the chance to speak to an asylum officer to determine if they have a credible fear of persecution and whether they should be permitted to stay to see a judge. Side note, I will try to stay off my soapbox, but this is one thing that I'm compelled to mention in every training. CBP has a hearing problem. They are required by law to ask everyone whom they apprehend whether they are afraid of returning to their country. Now, the context for this questionnaire is everyone from Central America has necessarily traveled hundreds and hundreds, 1,000+ miles to the U.S. border, and if they do not indicate they are afraid, they will be subject to expedited removal, and they will be sent all the way back to where they came from without getting to see a judge, without any due process whatsoever. Tell me then, how is it that 95% or greater of Salvadorans, Hondurans, and Guatemalans repeatedly, on 3 occasions, prompted by this form, answer the question, are you afraid? No. How is it that 95+% of these aliens whom Border Patrol interviews indicate repeatedly, emphatically, that they're not afraid, in effect saying, no, please deport me, sooner the better. So this is a hearing problem, and it is indeed so awful that when folks do get to see an immigration judge, they are most often, they're overwhelmingly referred by ICE, who's not required to ask these questions, than by CBP, which is. All right. So the credible fear interview is that at exit from the escape hatch from expedited removal. It is given to someone who has been arrested, who lacks proper authorization, and is, again, the default is expedited removal. The expression of fear, if it is heard, entitles someone to speak to an asylum officer for that officer to determine whether they have a significant possibility of establishing eligibility for asylum if they were allowed to see a judge. And all of our folk have passed this threshold. It's a low threshold, or it is now. It was not, none of y'all would probably be surprised to hear. The threshold was really rather high under the Trump administration, until a federal district judge pointed out that the asylum officers had been instructed to violate the law, and so the threshold was brought down again. Executive Office for Immigration Review, that is, again, the division of the Justice Department that houses the immigration courts and the Board of Immigration Appeals. This is where the alien, the respondent now, makes their first appearance before an immigration judge. And this appearance is called a master calendar hearing. It's very much like an arraignment in the criminal justice context. It is an opportunity for the judge to determine what the charges are against them. And the charges are simply that they're here without authorization. And how it is that they intend to proceed, whether they want to accept a removal order or ask for some relief from removal. For our folk, the only relief from removal that's available to them, with very, very, very few exceptions, is asylum. We'll go into those exceptions later on in the presentation. Here's where it becomes apparent that something like this agency, this organization, is really, really necessary, because the instructions that the judge gives folks who indicate that they want to apply for asylum are extremely difficult to follow. The form itself is in English. The instructions are in English. There is no official version of the asylum application available online or elsewhere in any language but English. And the instructions, likewise, are published only in English. The application, and it's not simply a matter of filling out the form and filing it with the judge, because there's all manner of additional requirements. Your passport style photograph stapled to the top right corner of page 9, and the 2 additional copies for each member of your family that's included in the asylum application, with their photograph, not yours, their photograph stapled on the top right corner of page 9 of the copy that correlates with the file with the copy. Anyway, I'm getting all jumbled up because it's hard not to. These requirements would be onerous for a college grad who speaks, fluent English, and our folks don't. So hallelujah that you're here to help them out. Oh, and there's more. Because after you filed your application in the manner I have just clumsily described, there is a further procedure which gets you your biometrics appointment. And if you don't follow these instructions, your application for asylum can be summarily dismissed. So here we come to completing Form I-589. And here I'm going to first recite these pointers, and then call up on the screen a copy of the I-589 itself. I hope it's apparent by context anyway, since I've been using I-589 and asylum application interchangeably. The asylum application is Form I-589. Pointers. Every mistake is a lie. One of the things that our folks can't quite appreciate, partly because I don't think that many of them have had any official in any capacity really like listen to them. But when answering questions that would seem to be really unimportant, like where are your brothers, there's a tendency among applicants, a very understandable one, to say, I don't know, but here's my best guess. Or, when did you move from one place to another? I don't know, but I guess it was summer. You're going to be fighting a certain resistance to precision, and it's not just that's for a host of reasons, many of them cultural. We put a great importance on sequence and dates that I'd say most other cultures do not. And certainly folks who are not from big cities, no matter where they're from, are not apt to focus on specific dates and sequences. They matter a great deal to city folk, and not to many others. So what I'm getting at is there's going to be a certain inertia you need to get over, a certain tendency to answer questions and just sort of best guess answers and to move on. Here's a problem. Skeptical judges are very apt to attribute the intent to deceive whenever it is that a discrepancy it comes to light. And it's I've seen it. I've been at this for 30 years, and I've seen it in come up in contexts that just make you want to cry. Like a fellow who I mentioned, where does your brother live? A fellow who said that in his application for asylum that he was that his brother was in Indonesia. Now, he was an applicant for asylum from Burma, and he months passed between filling out the application and the hearing. And when the hearing came up, the judge wanted to know where his siblings were. And we'll go into why it is that that's so often asked, but he wanted to know where his siblings were. And my client, he wasn't my client at the time, I picked him up on appeal, but my client had said, my brother's in Burma, which is again the country that he is from. My client is from Burma. Now he was saying that his brother was in Burma, and the judge suddenly lit into him. He says, "Wait a minute! He says here on your application for asylum he's in Indonesia." And my client, the discrepancy just caused my client to freak out. And within what must have been about 3 minutes of dialogue, he disavowed the entire application for asylum, because he says, he says, I didn't say that. And the judge said, well, you signed this application, didn't you? He says, but it's in English. And the judge says, but you signed the application. And he says, wasn't it read to you? He says, I don't understand English. And so the judge found him not credible. And it was excruciating to read this transcript and recognize how easy it was for him to fall into this trap, and indeed how easy it was in a way to have kept him out of it. You just needed, at the time that the application was filled out, someone needed to take the time and say, listen, this is really an important question. Every question on this form is important just because it's on the form. And if you're caught in the hearing answering a question that disagrees with what you've written here, the judge doesn't know that was a mistake. For the judge, every mistake is a lie. All right, every question should be answered unless it's clear that it doesn't apply. It says, what's your passport number if you have one, for instance. But if that's not the case, you would answer NA. Blanks are ambiguous. Avoid ambiguity by indicating on the form, not applicable. Again, within reason. I mean, you also have sections of the form where they're asking the names of your children. If you have no children or only one children, you don't need to fill out all the other blanks about children with NA, 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 NA. Okay, but within reason, blanks should not be. We should not leave blanks if doing so raises the possibility that you may have filled out the application carelessly. Answer questions as precisely as possible. Questions should be taken literally. Take the time to read the question literally. Judges can fault applicants for asylum sometimes for embellishing. It's not fair, but it's often the case that a judge will take an answer that is incomplete because the question was not completely translated to the applicant, and hold then fault the applicant for withholding information and embellishing on the day of the hearing. So answer questions completely. Dates are extremely important, even though most of our folks have very little notion of them. The temporal awareness is very different. Again, it's a cultural gap. Spellings matter. And finally, the motivation for any harm matters every bit as much as its severity, for reasons that we'll get into later. And this is not something that the applicant is likely to appreciate intuitively. Okay, now I'm going to pull up the I-589 itself. New share. Share. There we go. Okay, we're now looking at page 5 of the asylum application. This is the business part of the application for asylum. Now, I would, I'm going to scroll up a little bit to talk about procedure in the clinic. Unless Ana and Andres, unless you're going to, change ways, the way in the past, what we have done is at the conclusion of completing pages 1 through 4, which are biographical information. You can see alien registration number, last name, address, date of entry, place of entry, name, and biographical information of spouse and children. Then places you've lived, last address outside the United States, where you were educated, where you have worked, where you've worked. This is something I want to emphasize. Our folk have an understandable, are understandably reluctant to provide information about employment that they have or have had that was unauthorized. This is for very good reasons. One, they don't want to get themselves in trouble. 2, they don't want to get their employer in trouble. But they must list every application on the form. Every answer on the form needs to be honest. And to the extent, I mean, and I say that with like must be, like if an applicant tells you they're working and then will not include the information about their employer, or insists that that you indicate on the form that they're unemployed, that's it. That's it. I mean, that much as we would like to help them, you can't assist someone in what you have learned is a lie. Okay, and we're not coy about. We're not. We don't. There's no preamble that says, well, whatever you tell me, I have to put on this form. So wink, wink. Are you working? No. The truth is that without some radical change in enforcement priorities and patterns, this will do no harm to the client or to the employer. It's actually beneficial to show candor. Okay. Again, I'm speaking from 30 years doing this. I have no employer, to my knowledge, has ever been gotten into any hot water over this form and an honest answer on it. Nor have I seen any applicant for asylum get the third degree because they've worked without authorization. It is understood. It happens, and in truth, the candor is an indication that your guy, this alien, so-called, is one who is straight shooting and can be trusted to speak the truth. So you need to push past any resistance and include the names of employers, even if the work is done on without authorization. Okay. And one last note on a tricky series of questions. As I indicated, this question about the location, the present location of parents and siblings can be sticky. And the reason for this is that judges will sometimes perceive the siblings and parents of an asylum applicant as sort of the canary in the coal mine. If they're present in their country, if siblings of the applicant live still in, say, El Salvador, and they're not in any danger, then the judge will at least want an explanation for why it is that their circumstances distinct from the applicants. Okay, so it is relevant, and it's in the questions on this particular on these about these family members can get persistent and pointed, and if you haven't given a lot of thought to the precise answer, and if you haven't, like you have applicants who want to leave off half siblings, don't. So if you're related by a parent, by father or mother, you need to include those siblings, and you absolutely must not stop the list simply because you've run out of blanks. Okay, and that's true for all of the questions on this form. So not stop simply because you've run out of space. You can continue on an addendum, and you must. Okay. So normally, or in the past, we have asked asylum application preparers to stop after page 4 and complete a form, which I don't have to share, a asylum claim inventory. It is a one-page form that breaks down the application into its legal components. And it's a good way for the supervisor to make certain that before the volunteer begins telling the applicant's story, the volunteer has a full appreciation of what the theory of the case is. What's the relevant information? Relevant information. Since we don't have the form, I will give you some examples. The inventory will ask: has the applicant gone to ask for the help of the police? And if they have not, why not? Has the applicant tried to find safety in some other corner of their country? If they have not, why not? And then also, critically, what is the motivation behind the persecution that the applicant has suffered? We will get into the critical function of motive when it comes to determining whether someone's a refugee. But for now, this is mentioned that this is one of the reasons why we have in the past used the asylum claim inventory as sort of a stopping point, a moment when the volunteer can try to get, as it were, to the bottom of the case and get the approval of a supervisor before moving on to tell the applicant's story on pages 5 through 8 of this form. Okay.
Oh, Paul, just a minute.
Yes,
Just to comment on that topic of the asylum inventory and the basically the mechanics of this rebirth of this clinic, we're doing it mostly virtually, or at least not in a workshop setting, which is
Right.
People don't come for a whole day, and then at the end of the day, all the information and everything is collected. So what we've done is that the the biographical information, first we have a consult, because you can't accept anybody off the street that just knock at your door. You have to have a bona fide lawyer or accredited representative, have a consult with the person and determine whether they qualify for an asylum claim.
Right.
And then they would be like, eligible to be assisted by the clinic. And then after that, then we sent, because now everything is virtual, so we sent them first for the consult. Oh, they have to fill out a Google form, and then that's the basic information. And then after the consult, if they if they qualify, then we send them another form, and that that form provides all the it asks for all the information in the biographical section. And then they go in a list, and then when we have, and then they're like in a list waiting for volunteers or volunteers. And so once they get assigned a volunteers, then they take over from there. And then of course,
what usually will happen at that point is, once they have the biographical information, then we will set up a Zoom with the person who is the principal, I call them, the person who is doing the application, the participants, the asylum seekers, whether it's a family or one person, and usually me or Andres, or an accredited representative, or someone who is very well versed in this. And so we will be kind of like as a just to make sure that everything's okay. But we've gone through, the things that are important in that inventory that you mentioned, but we haven't been going through the inventory. So we've been doing this as kind of informally.
Brilliant. Okay. All right. Thank you. And I think probably everybody benefited from that, not just me. And I apologize. I hope that I haven't wasted anyone's time these last few minutes. But yes, I simply hope that. Let's leave it at that and move on. The page 5 of the asylum application is where the rubber meets the road. The first question on that page is really a mouthful. When it is when I'm doing this live, I'll ask someone to read this aloud. But I'll do it myself and avoid and lose some of the give and take. But oh well, we'll just roll with it. Have you, your family, or close friends or colleagues ever experienced harm or mistreatment or threats in the past by anyone? Now, this is a fine question to a fine moment to point out the importance of breaking down a question and treating it literally. If you consider this question sort of analytically, there's not one question here, but actually, I reckon 12, because it's a grid. Have you, stop, your family, stop, close friends, stop, colleagues, ever experienced harm, stop, mistreatment, stop, or threats in the past by anyone? So this is a huge net. This is a mile-wide drift net. You don't get to focus on the stuff, only on the stuff that your applicant wants to talk about. You need to be very careful to reach all the corners of this net. and it's very large. So you'll want to, with the applicant, you want to break it down. Have you experienced harm? Have you experienced mistreatment? Have you experienced threats? Has any member of your family experienced harm, experienced mistreatment, experienced threats, close friends, etc.? So the application, with this example, I just want to underscore the importance of breaking down these questions, treating them literally, and answering them completely. Okay. Just to illustrate the importance of it, I will speak of another case, Congolese client who came to me again after being denied, after having been found not credible. Came to me with her case on appeal, and the judge had asked her at the very, very end of her testimony, is there anything that you haven't mentioned? Is there any member of your family who's ever been come to any harm in your country of the Democratic Republic of Congo? And she says, well, Your Honor, yes. And he says, what's the story? And she says, well, I didn't mention this because it happened 15 years after my arrest. And but it was a cousin of mine who was arrested and imprisoned and tortured under the regime overthrown by the regime that persecuted me. In his decision denying her asylum, the judge cited this last-minute embellishment as one of the reasons why he had to conclude she was a liar. So pay attention to the full sweep of questions like this and make sure that you answer them completely. It would be a great pity if a question that was answered in haste led, like in this instance, to a finding that the applicant was lying. All right, so, whoop, that's not the one. Try again. Where the devil, here we are. There we are, okay. So when you interview an applicant for asylum, you want to, especially if it's a child, but this is true for anyone who's not as sophisticated as you are, and that's going to be like almost everyone who comes through this program. You want to simplify your sentences and words, i.e. don't talk like I do. Use concrete and not abstract terms. So instead of arma de fuego, you want to say pistola, or just try to simplify your sentences, simplify your terminology. Avoid leading questions that suggest what the answer you want to hear, because in the hearing, that the judge isn't going to ask them the questions that way, and things could all fall apart. And they also can prompt the applicant to, especially if it's a child, to tell you what you want to hear, even if it's not quite true. And in this, with children, as with any applicant for asylum, try paraphrasing the question on occasion if you have any doubt that or try asking the applicant to paraphrase the question if you have any doubt that they've understood it. Okay. Some of these questions really are pretty abstruse, so or the concept. And this emphasis on the motivation for the harm is sometimes really hard for the applicant to appreciate, because really what they want to talk about are how bad things were, not what motivated the what. For instance, very good example is if it's a domestic violence case, very often the focus will be on the awful things that the fellow did, without sufficient attention to what he said. It said, I mean, what does it matter what he said when he just sent you to the hospital with with his actions. But the words are critical because they can reveal whether the persecution is quote unquote qualifying persecution. That is, if it was motivated by one of the 5 so-called protected grounds. Here's another teaser. Okay, testing the depth of an applicant, this test story with kindness. It is critical that you there's sort of a lull that sometimes sets in, a sort of a routine that sets in with all of this. And when that routine is broken, there can be a tendency to, to jump to really overreact. Reaction, especially when a child tells you of some harm that's befallen them, you don't want to contribute to their sense of stigma. And so it's really important to just, chill. Empathy, yes, but also a sense of propriety and simple appreciation for the trust that's been shown in you. I want to leave this up for a moment longer. This is, by the way, this 12-year-old Ramon is now, who came through the clinic, is now a U.S. citizen. So, yeah. Someone took his case on pro bono. He did not proceed pro se. He continued with a lawyer. Okay. So when you complete the application for asylum, I don't know the mechanics of it, but I want you to understand something, that ultimately whoever signs this form is stating that the application was read back to the applicant. Before you part ways, whatever your role in the preparation of this application for asylum, please ensure that it is read back to the applicant, because when this clinic has completed its work, the application that will be given the applicant will have the signature of some preparer, the principal, presumably, and that person is saying that the application has been read to the applicant. If that hasn't been done, you run the risk that you may have put the wrong words in the mouth of this alien, again, so-called. And go ahead.
One of the things we're going to try to do, we've done it for the first one we've already done. We're trying to get Spanish speakers who cannot come and do the main principal part, but if they want to volunteer translation services, they can take the application and translate it into Spanish afterward, right, so that we can send them the actual thing. What we've noticed is when we used to read it to them and have them audio recorded in their phone, yeah, many times they would lose it. And then they would call me and tell me I lost my phone, I did this, I did that. And so it's very frustrating. So one of the things I would like to do, I don't know if it will be feasible, but I would like to do that, is to be able to actually translate the finished application into Spanish to be able to give to them.
Wow, that's an undertaking. That'd be great. That's a brilliant idea, Anna. I hope that works out.
Yeah,
I hope that we do have resources. Yeah. Okay. So when the applicant gets to the point where they're presenting their own claim for asylum, the good news is that virtually any evidence is admissible in court. The bad news is that there are all kinds of requirements that have to be met regarding the form for the form one has to follow, and the timeline for the submission of supporting evidence. The clinic helps folks as best we can with supporting evidence, but it is but it's still going to be a tough row to hoe for our folk after they've left the clinic. These filing requirements are pretty pretty demanding. Our office still gets things rejected every once in a while from the court because we've forgotten to include a certificate of service, or something else is awry, and so they don't make it easy. In the final hearing, at the conclusion of the presentation, after the application for asylum has been submitted and any evidence has been submitted, the names of any witnesses have been submitted, the merits hearing, so-called, or the final hearing, the individual hearing takes place. And at that time, the judge interrogates or questions the applicant for asylum. And then the trial attorney, the ICE attorney, does likewise, and it's back and forth until the judge is satisfied that he or she has enough information, and then that usually at that very moment dictates a decision. The denial rate, even with our help, is going to be really high. The great majority of these applicants are going to have their cases denied. This is, however, a point where an appeal can be filed, and it just needs to be filed quickly. It needs to be filed within 30 days of the judge's decision. And I have said to all participants that they may, and the offer still stands, if anybody has been denied asylum and wants a lawyer to help them with the appeal notice, and that should be like everybody who's been denied asylum, I'm happy to do that. I will not charge. I can distill from whatever they have to say about how the hearing went. I can discern what the judge's reasoning was, and if I find fault in it, and I always do, I can help them with an appeal notice.
All this is being recorded, so
okay, all right, okay. I always do, because the application of immigration law to the facts in a specific case is always subject to different points of view, different perspectives. Bear in mind that among judges, there are judges that deny asylum at a 95, 98% rate. And there are judges who conversely grant asylum. I don't think quite to that with that frequency, but there are judges that are still granting 70+% of claims. So
not in Texas.
Not in Texas. So the notion that that a client might, or a participant might come to me with an application or a decision which is absolutely appeal proof is pretty fanciful. There will be something in that that is, I think, sketchy, an argument or a criticism that I think is unfounded. And so, yeah, thank you for reminding me that this is on air, so I shouldn't be quite so glib. But yeah, in all honesty, I have never yet interviewed someone post hearing and not found a basis for it and for an appeal. Okay, so now we come to the hard stuff. Believe it or not, this is this is the I think the more than the procedural difficulties in filing an application for asylum, the most important reason for a clinic like this is the law. The asylum system allows the grant of protection only to those who are refugees, and refugee is not what you think it is. It's a very narrow, very specific definition. It is a person who is outside the country of that person's nationality. There's a narrowing factor right there. It has to be outside. The person has to be outside their country of nationality, and is unable or unwilling to return to that country because of persecution or a well-founded fear of persecution on account of race, religion, nationality, membership in a particular social group, or political opinion. This breaks down, I see it thus. The persecution must be either past or reasonably feared. It must be committed, and this is implicit, but it must be committed by the government or an entity the government cannot control. And it must be on account of a protected ground. And what these protected grounds, as listed in this section of the Immigration and Nationality Act, are race, religion, nationality, political opinion, or membership in a particular social group. Okay. Again, persecution. So to qualify you for asylum, the persecution that you fear or the persecution that you have suffered must be or have been on account of your race, on account of your religion, on account of your nationality, on account of your political opinion, or on account of your membership in a particular social group. Now, your mind may already have sort of jumped ahead to, wait a minute, since when do gangs, at least typically, persecute on account of their victims' race, their religion, their nationality, their political opinion, their membership in a particular social group? That doesn't seem, and that indeed it is the rub. That is where your mind is going is where we hit run into difficulties with these very, very heartrending stories of persecution, past and feared. Okay, what is persecution? Persecution in at least within the jurisdiction of the Fifth Circuit Court of Appeals, which is to say Texas, Louisiana, I should know this, Texas, Louisiana, and somewhere else. The Circuit Court of Appeals has held that persecution, to qualify one for asylum, has to be really, really awful. There are different courts that have different views of how severe the persecution has to be. The Fifth Circuit is one of the most demanding. So a single instance, single beating is very unlikely to qualify as persecution. Threats, even repeated, are quite unlikely to amount to persecution. There are exceptions. Even the Fifth Circuit has acknowledged that in certain circumstances, threats can be persecution. And I would insist that even within the Fifth Circuit, a single instance of rape would qualify as persecution. The being a victim of past persecution can suffice. You can be recognized as a refugee and eligible for asylum based solely upon the persecution you've suffered in the past, if it was on account of one of those 5 protected grounds. You can qualify as a refugee because the persecution that you suffered was so god-awful that it really, the right thing would do would be to keep you, to not require you to return. There's an excellent example of this might be somebody fleeing, who fled Rwanda. The genocide in 1994 was, to knock on wood, was a one-off. Yet you, with that genocide, like the Holocaust, it is recognized, and now it's codified. It's in the regulations, the Code of Federal Regulations, that persecution that's sufficiently severe can justify a grant of asylum without any reasonable fear, indeed any fear at all, reasonable or otherwise. There's another mechanism for a grant of asylum, and that is based on solely on past persecution, is that there's a legal presumption that arises if you've been persecuted in the past for one of those 5 magic reasons. It's presumed that your fear of persecution is well-founded, and it becomes the government's burden to disprove, and the government's burden to prove that there's some corner in your country where you could return to safely. And that is a burden that is very, very seldom met. So past persecution in itself, if it's for the right reason, can qualify someone for asylum. And aliens, when is a fear well-founded? It kind of comports with what I think of as common sense. The alien possesses a belief or characteristic that the persecutor seeks to overcome. The persecutor knows or is likely to become aware of that characteristic. The persecutor is capable of punishing the alien, and the persecutor is inclined to punish the alien. Let's take an example that is too common in Central America. You're gay, and the Mara Salvatrucha gang has threatens to kill you. One really chilling way of putting it, expressed to me by a client, was a gang member said to him, homosexuals, and he didn't use the word homosexuals, must pay to live. In other words, he would either pay what they demanded of him what they demanded when they demanded, or they would kill him for being not like them. The fear is well founded. So in this instance, the gang that he possesses a belief or characteristic that the persecutor seeks to overcome. The persecutor knows or is likely to become aware of that characteristic. The persecutor is capable of punishing him, and the persecutor was inclined to punish him. A fear is well founded when that persecution, when folks who are similarly situated are being persecuted. That interest that the judge had in my client's brother, who was in Burma rather than Indonesia, that the judge was going after that. Was the brother similarly situated? And if so, why was he not being persecuted? And then the Supreme Court gave us a very helpful benchmark. A 10% probability of persecution is sufficient to give rise to a reasonable fear. Reasonable and well-founded are used interchangeably. So a causal nexus must be shown between the person's characteristic and the persecution they have suffered or feared. So in a best case scenario, the persecutor with the raised machete says, "You stinking such and such," before bringing it down. Okay, that would be a showing of nexus, a causal nexus between the characteristic that you have, the protected trait, and the persecution that you have suffered. Unfortunately, of course, needless to say, I have to go back, that the causal nexus is almost never so clear. Not in our Central American claimants, anyway. I mean, it's even with political persecution, it can be dicey because where does the line between persecution and prosecution lie? But with the gangs, it is and indeed sadistic spouses. It's not often that you find a very explicit expression of the motivation for the harm. So a particular I've redone these slides, and I just I'd forgotten that I cut a couple that I have used for transition. Okay, so in Central America, it is seldom that persecution is on account of race, on account of religion, or on account of nationality. I mean, think about it. If the persecutors, by and large, that drive our folk to flee their countries are either violent companions or gangs, their motivation to persecute others, to harm others, is not generally racial, it's not generally religious, and it's not generally based on the victim's nationality, and it's not generally based on the victim's political opinion. Most often, what we find ourselves working with is a claim eligibility based on some conception of a membership in a particular social group. Okay. What is a social group? A couple of things that can be that have been recognized as social groups, particularly social groups. Former military officers, former soldiers, has been recognized to be a particular social group. Recognized also to be a particular social group, at least in certain in Cuban contexts, homosexuals. There is little question that these two and a very few others are beyond, are beyond challenge. Unfortunately, what has transpired in the last, really the last decade, really, is there's just been these radical swings regarding the scope of particular social group. Its applicability to things like, families and women. Under the Obama administration, there were cases that acknowledged that married women could be recognized as a particular social group in certain circumstances, and members of families could be recognized as members of a particular social group in very, actually fairly common circumstances. Under the Trump administration, those decisions were repudiated, and now they're back. So it's getting a little, there seems to be a terrible wobble. Right now, you can rest, you can rest upon the judges accepting married women as a particular social group, at least in certain contexts, and membership in a family as membership in a particular social group, and Pache, Donald Trump, that family doesn't have to be famous. that was the spin that was put on family as particular social group in recent years. It had to be a famous family. That interpretation has since been done away with. So particular social groups, broadly speaking, now it's panning back and talking about the concept, particular social group must be made up of individuals who share an immutable characteristic or one that is fundamental to their identity. So there could be characteristics that are mutable, but are so fundamental that the alien should not be expected to change them. The example of a characteristic that is mutable but fundamental would be, the choice of a romantic partner. Right? It was not so long ago that it was very difficult for one to receive asylum if a judge were to find that it was possible for you to return to the closet. Fortunately, we no longer encounter decisions like those, but the principle remains that if the attribute that you say you share with other members of a particular social group is changeable, then you have to establish that changing it would be that you should not be required to change it because it's fundamental to your identity. Before this last swing, as it were, to the right, the Board of Immigration Appeals had already had a go at particular social group. It was perceived as too embracing, and so particular social groups were required to be recognized. They needed to be defined with particularity, and they needed to be socially distinct. As it happens, these are contradictory traits, and if your intent is to limit the number of people who get asylum, particularity and social distinction working together can virtually eliminate particular social group, like just erase it. I'll show you how. Particularity. The board has held that a particular social group must not be too amorphous. Okay, the boundary between who's in and who's out must be this must be crystal clear, and it must not be a group that is potentially too large and too diffuse. Well, I point out here that by this definition, depending on what spin you put on these words, the Tutsis and the Tutsis that survived the massacres in Rwanda in 1994 would not be viewed as refugees because their membership in a particular social group defined as as their Tutsi label that they wear was too large and diffuse. So if you were one of those who escaped the persecution, presumably you would not be a refugee if this definition, if this requirement were strictly applied. And for 4 years, it was indeed strictly applied. Social distinction. Particularly social groups must be visible or socially distinct. To have the social distinction necessary to establish a particular social group, there must be evidence showing that the society in general perceives, considers, or recognizes persons sharing that characteristic to be a group. So in effect, you're expected to show through expert witness testimony, or at the very least through your applicant's testimony, that if an imaginary Harris poll were conducted in their country, that everyone would recognize the existence of the particular social group to which you claim to belong. Now, in effect, to sort of simplify this particularity and social distinction, what you come down to is sort of a Goldilocks, not too big but not too small, not too big but not too small. And if your intent is to prevent people from applying for asylum, these dueling requirements can effectively, as I say, erase particular social group altogether. And this is what I pointed out. Attorney General Jeff Sessions offered this this grim assessment of the effect of the competing requirements. Particular social group definitions that seek to avoid particularity issues by defining a narrow class, such as Guatemalan women who are unable to leave their domestic relationships where they have children in common, will often lack sufficient social distinction to be cognizable as a distinct social group. At this moment, I feel I should twirl my mustache like a good villain. For the last few years, it was, in effect, a particular social group was gone. And that's fortunately no longer the case. So let's not dwell on the past. There is a way to find your PSG without a GPS. Sorry, I had to keep that slide. It was rather quick.
That's a new slide.
The space between particularity and visibility is now wide enough for us to steer a safe passage. Okay, women. The Board of Immigration Appeals has acknowledged that married women, specifically married women in Guatemala who are unable to leave their relationship, can constitute a cognizable particular social group. Okay, it has the requisite particularity and visibility. Okay, so hallelujah. And the board in unpublished decisions has made abundantly clear that you don't have to actually be married, and that the unable to leave their relationship doesn't actually mean physically unable to leave the house. They've granted asylum to women who have spent years, going hither and yon, trying to find a safe place in their country. And even though they've physically left the household, it's apparent that their companion or former companion will not let them get on with their lives peacefully. The board has also acknowledged that families can be a particular social group. And let me give you an example here. If a youngster, a young male, is recruited by a gang, and he won't go and he won't go, the case law regarding any particular social group claim that he might make is dreadful. I mean, he can say he could claim to be a member of the particular social group defined as Salvadoran youth and La Union between the ages of 12 and 15 years of age, or any number of variants. The courts have all almost without exception said, get out of here. It's not a particular social group. It is too amorphous. It lacks specificity or particularity. Go home to be persecuted. But in this instance, if the applicant for asylum is not the child, but the child's mother, and the gang threatened her life, saying, "Look, if we have to come more and more time knocking at your door, we know your kid thinks he's going to protect you. It's you. We're going to make an example of you for him and all the other kids that don't want to join up. Okay, think they're better than us." In that instance, mom can make an asylum claim based on membership in a particular social group, that being the immediate family of the direct victim of the gang's persecution. It seems it is counterintuitive. It is, and this is something that's kind of hard to wrap your head around, because in fact, the degree of danger is usually greater for the child than for the mother. Nevertheless, the mother has a viable claim, the child does not. Okay. So it should be noted that the Biden administration has not taken from judges the authority granted them by the Trump administration to pre-termit applications for asylum. It was thought that they might clear much of the backlog of asylum claims by allowing judges to just read the application for asylum and say, meh, and toss applications without actually taking any testimony, summarily dismissing applications for asylum based on the written rendition of the claim. Now, though I don't think that a judge would dare, again, the judges work for the Justice Department. They are constrained by policy. They work for the Attorney General. I don't think any judges hereabouts anyway would have the nerve to pre-termit an application for asylum because it is not cognizable without actually hearing testimony. But that time may well be on the horizon for our folks. The applications for asylum that we file may well not be adjudicated under an administration that has that's pro refuge, pro refugee. So bear this in mind when you're filling out the form, when you're helping to complete the form. Think of other things that protected grounds besides particular social group that might be specified. One possibility is anyone who has refused to participate in the gang may, depending on what motivated them to say no, there may be a political opinion in there. There may be a religious opinion, a religious faith that underlies or undergirds their resolve not to help the gang. If this is so, mark the box. And as you narrate the story, make sure that there is mention at least of the applicant's motivation for refusing to assist the gang or resistance to their demands. The idea here is to try to inoculate the applicant against a decision denying them asylum without having been heard. Okay. When you present a social group, it must not be circular. So if you were to say Salvadoran youth who've been persecuted by the gangs, you're in a pickle because the persecution can't. In this instance, you're defining the particular social group by the persecution, and that's a tautology. You cannot do this. You must. The persecution must be to some degree apart from and separate from the definition of your particular social group. Back in the under Attorney General Sessions, there was this circularity critique was applied to women. That Guatemalan women, particularly social group that had previously been accepted. The Attorney General pointed out that, well, if the woman is unable to leave their relationship, it's because of the persecution, right? So there's circularity. It can't be a particular social group. Again, that decision has since been flushed as it should have been, but it's still, the critique is still valid, even if not valid applied to that specific instance. Avoid circular particular social groups. And then finally, if there's any degree of government complicity in the persecution, or if it appears that the government has turned a blind eye to the persecution the person has suffered or fears, you should also indicate that you're applying for asylum under the Convention Against Torture. What does that mean? It just means marking a box. There's a box at the top of page 1 and another box, oddly enough, on page 5 that prompts you to answer the question whether you're applying for asylum based on the Convention Against Torture. The answer pretty much, I'm not going to say invariably, but in most instances, the answer should be yes, because there is a way the degree of government in the willful blindness of the government to the persecution of our folk is, I think, rises to the level of qualifying many of them for relief under the Convention Against Torture, which I'll get into in a moment. It's a little bit, it's closely related to asylum, though a little less generous. Okay, here we go. And we're nearing that point now where we discuss CAT, so-called Convention Against Torture relief and withholding of removal. Materials, there are those who can show well-founded fear of persecution or who have suffered qualifying past persecution who are nonetheless ineligible for asylum. Very, very, very fortunately, judges have not focused on this ground of ineligibility, and I just think it's out of a sense, I gotta say, it seems to be out of a sense of decency. The board has held in a decision that has not been overturned that in effect, any assistance at any time to any organization that is ever engaged in violence against any government for any purpose at any time is ineligible for asylum. And that is true even if that assistance was coerced. The dreadful reach of this principle is illustrated in the case itself, the case, the facts in the case that had the board determined that a woman was ineligible for asylum made, well, here they are. The woman had been forced to witness her husband dig his own grave before being killed, and was thereafter, this woman was thereafter held as a slave, cooking, cleaning, and washing clothes for a guerrilla organization in El Salvador. That her actions as a slave done on pain of death were material support to a terrorist organization and disqualified her, said the board, from asylum. Now, if this principle is applied broadly, it disqualifies virtually any of our applicants, any of our folk who have ever succumbed to extortion. Think about it. This treatment of the material support to terrorist organization basis for denying asylum is breathtaking and nauseating in its scope. We hope, and as you know, you talk, Andres, about making this available. Some of what I say, I don't want it to fall into enemy hands. The judges so far have overlooked, in my experience, and from what I hear from colleagues, have overlooked this basis. But if somebody is inclined to deny asylum, this is a anyway. Enough said. Okay, there's a 1-year filing deadline, and this is a really delicate issue, not unlike the first. Under the Immigration and Nationality Act, aliens are required to apply for asylum within 1 year if they're going to apply at all. And here's the weird sort of, through the looking glass reality that we've lived in since this law went into effect in 1997. The agency, unbelievably, the Department of Homeland Security, never told anyone about this 1-year deadline. And for the life of me, I still haven't seen anything indicating that they have shaped up. Since 1997, they have been screening people to determine if they have a credible fear of persecution, to determine if they should be allowed to see a judge, and then pretty much systematically denying them the right to asylum because they don't even get to see a judge most often before a year has passed. So what has transpired is that a federal district court held, I guess about a year and a half ago now, that because the government was systematically withholding from aliens any knowledge of the 1-year filing deadline, they were basically kind of playing Lucy in that Charlie Brown cartoon with a football, and just setting aliens up one after another for failure. And the judge pointed out, in effect, look, there's a provision here that says that if the 1-year deadline is waived, if the failure to file was outside the alien's control. Well, guess what, guys? Y'all over at DHS, every single alien who failed to file their application for asylum within 1 year of entry, whoever came through your custody, it's your fault. So there's a requirement. Unfortunately, I wish it were quite that broad. There's a requirement that the alien have the sophistication to file a specific notice of eligibility under the Mendez-Rojas settlement agreement, but provided that they can mention this open sesame language before March 30th this year. Actually, I guess it's mid-April. They got the
April
date.
22.
Thank you. Yeah, so it's actually not a March 30th. They're just another example of DHS malfeasance. They published all kinds of materials indicating the deadline was the end of March, and it's not. It's 2 weeks later. At any rate, the 1 year deadline is there. It can be avoided until March 31st with the recitation of a certain magic phrase, and thereafter, though, we're back to the 1 year deadline in its full force, and evidently no discernible change in DHS policy, back to same old, withholding from aliens any knowledge of the 1 year deadline.
But then, Paul, can't we just continue to write up this Mendes Rojas?
Yeah.
And take our chances?
Yes, absolutely. We should still assert the right, and there's the hope that the district court may expand the temporal reach of its order, because DHS was supposed to by now, and said they had begun universally telling people of the 1 year deadline. That's still to meet. I've yet to meet a prospective client who has heard anything of the deadline from the good men and women of DHCBP or ICE.
Well, not only were they supposed to tell them, but they're supposed to have it in writing, and there's no such thing.
I haven't seen that notice. Really, it's like that. It's one of those things like that 95% of aliens repeatedly and emphatically disavow any fear of returning to their country. That just makes your head spin. You just wonder, what are these? Are these like, just like I don't understand it. I don't understand it. And I interact with people. The truth is that I interact with people all the time working for DHS and CBP, and I haven't met one with horns and a tail yet. And yet, as an organization, in some instances, they seem to be possessed. All right, enough. INA, withholding of the removal. I mentioned it earlier. If you don't qualify for asylum, say because you filed too late, or because you gave material support to a terrorist organization by, paying off someone who was going to kill you. The INA says that you may be granted something that's a lot less generous than asylum. It's called withholding of removal. If you can show that the persecution you would suffer on account of race, religion, nationality, membership in a particular social group, or political opinion, if that persecution is more likely than not, as opposed to simply, reasonably feared, then you can be granted withholding of removal. I'll tell you what that is in a moment. But first, the Convention Against Torture also permits a grant of withholding of removal if it can be shown, if you can convince a judge that it is more likely than not that you will be tortured, and that's worse than persecution, tortured by either by your government or by an individual your government is like allowing to persecute you. It's willful blindness is the standard. The government, there must at least be that degree of government involvement. Now, withholding of removal is, as I've indicated, less generous than asylum. The judge, it's really odd, the judge orders you removed but forbids your removal to your country. You are allowed to stay here indefinitely unless you misbehave really badly, or they find a place that will take you. The thing is that for the rest of your life, you'll be renewing your work authorization annually, meaning, of course, if you live in Texas, that's also an annual trip to the Department of Motor Vehicles, because you'll only get a driver's license for as long as you've got work authorization. So it is its own little hell, an annual trip to the DMV. All right, alternatives. There are other alternatives to asylum. Those who are eligible for either a special immigrant juvenile status, T visa, or U visa might well not want even to apply for asylum, because these are they're more likely to get this benefit, and it is indeed in some respects more generous. Special immigrant juvenile status is available to children from broken homes. quite simply. T visas are available for victims of trafficking, and U visas are available to certain victims of serious crimes. Basically, a U visa applicant needs to get a certification from a law enforcement official that they have aided in the investigation or the prosecution of that awful crime to which they were a victim.
Paul, I wanted to mention here about the, well, I mean, as an immigration legal agency, we deal a lot with U visas, not so much with T visas, because human trafficking is typically prosecuted by the FBI and so forth.
Right.
And so it's more like an organized prosecution of TV,
Right.
To find that. But the U visas, anybody that can report the crime and it qualifies, then we take care of them. But more importantly for this clinic is that we've started, I mean, we already have a backlog of, we have a list of 10 youth that qualify for special immigrant status. But the problem there is that there is a step in the family court. You know, the family court has to determine that the youth has been abandoned by at least one parent. And then there is some paperwork to be done. And that's, you know, family law. I mean, you're an immigration attorney. This is for the family attorneys. And so what we're trying to do is to set up teams of volunteers that are trained by family lawyers to do the paperwork, and then find pro bono attorneys that can file it with the proper family court. So that's another part of the clinic that we're starting.
Brilliant.
Yeah, and we should be having a Zoom like this one for SIJ probably within a month or so. So keep your ears out for that.
I'll keep my ears out for that. Okay. Thanks, Andres, for speaking up. Okay. So the work authorization. Work authorization is something of a chimera. It's a mythical beast for many applicants for asylum. Here's why. The illustration here with a donkey and the carrot is to illustrate what happens with many, if not most, applicants for asylum and their hope for work authorization. You get to file an application for work authorization 1 year after you have filed your application for asylum if it remains unadjudicated, but only if you have not caused a delay in the processing of your application for asylum. It gets hyper technical, but if you can, if the judge determines that you ask for a continuance, or you asked for a change of venue, or basically you did anything at all to delay, just slow the processing of your asylum case, you are out of luck. It's actually all the more important these days, if you possibly can, and this is the slide should mention this, I neglected to update it. But Andres, Ana, you're familiar with the ASAP program, I presume? Yeah, everybody should be signing up for this Mickey Mouse Club. There's an organization, the Asylum Support. I don't know what ASAP stands for, but at any rate, there's a federal district court case that says that members of ASAP cannot be required to wait a full year before they can apply for asylum, before they can apply for work authorization. And strangely, bizarrely, the membership of that group, that ASAP membership, is not defined. So the agency that won this lawsuit has broadcast as best it can, far and wide, that sign up, please sign up. And I'm guessing that by now tens of thousands of people who have absolutely no familiarity with this agency whatsoever, and probably a dozen of my clients among them, have signed up in order to be able to apply for work authorization at the 150-day mark rather than waiting a full year. And
Yeah, the number is like it's approaching 250,000 members of this ASAP group.
Yeah, and that stands for Asylum Seeker Advocacy Project.
Right.
And it started out with a few lawyers from Yale, and they've really grown exponentially. We did interpretation for them at the beginning.
Yeah.
So yeah.
That's fabulous. And I just, it beggars belief, but it's there. And it's really important. I would say, look, it's really important to take advantage of it, not just because of the 9 months of the potential work authorization and the avoidance of an $85 filing fee, but beyond that, those circumstances that could arise that could cause the judge to say, you caused a delay. Well, if you've already got work authorization, that's no longer applicable. So you get out of the shark tank, as it were. You get out of the piranha tank, I guess, if you can get your application for work authorization filed and granted before the judge can jerk you around and manufacture conditions that would cause you to be denied your work authorization. So ASAP is fabulous. Okay, but I think I may have got lost in the weeds. Asylum applicant. I'd said earlier that if the applicant for asylum insists upon saying something, retracting what they just told you, like say about their employer or what all, they don't get takebacks. Yeah, maybe they said something that was mistakenly, and now they're correcting themselves. I'm not saying that they don't get to correct mistakes that they have made, but but you don't get to hear something and then wink and allow them to change it. So an application for asylum is frivolous if any of its material elements is deliberately fabricated. A frivolous finding is banishment from the United States for the alien's entire life. So don't mess. Don't run the risk that an application is going to contain a falsehood if you have any inkling that that your applicant is fibbing to you. Okay. So if you're, there are a few folks who come through this clinic. I don't even, whatever the ratio is, it's nothing to boast about. The percentage of folks who come through the clinic who've been granted asylum. Truth is that some have, right? We do know that some have, including that youngster Ramon, who's now got citizenship. And if they do, or if they are granted asylum, this country's warm, muscular embrace. You get employment authorization, you get right to reside in the United States indefinitely, the right to travel, eligibility to adjust your status to a green card a year later. You get refugee benefits, which include health care, and laugh like that's we all have it anyway, but healthcare benefits and job training assistance and all that good stuff, as if they just got off the came out of DFW from Iraq. So it's a really good deal. If I would add, again, fairly typical for this system, no one's told about this, and I would venture to guess that among those granted asylum, no more than 1 in 5, and certainly in this town, no more than 1 in 20 folks who get asylum actually apply for refugee benefits, because no one tells them that they're out there. So in sum, why fight this losing battle? As I've indicated at the outset, it's often true that the closest folks are going to get to winning their request for refuge in this country is losing slowly. And that may seem like, small potatoes to you and me, but they can't be deported. With an application for asylum unadjudicated, they can't be deported. They're safe, and their children are safe. The law may not care that they die if they don't die for the right reason, but I do. And if you're on this, if you're in this class, you do too. You can change the law by winning hearts. One of the things that lawyers that I heard in law school the first time, and I've often repeated it since, when the law is against you, argue the facts. When the facts are against you, argue the law. There are many cases that come through here that are, in fact, the great majority of them present really very compelling stories. The suffering is real. The danger is real. And it is, there are situations where judges will simply, or either a judge or an ICE attorney will simply stop will care less about what the doctrinal basis for an asylum claim is, because, for instance, the alien showed up in court with one arm, having lost the other to violence in her country. And in such an instance, the ICE attorney just might join with the advocate for that woman and saying to the judge, Your Honor, the government does not oppose a grant of asylum. And in such an instance, the judge might say to the government lawyer, do you realize that you are violating your professional ethics? And I am thinking of ratting you out to the Texas bar. And in such an instance, the trial attorney might say, you try it. I'm holding my ground. Both sides.
And then some nice people get her the prosthetic arm, and that's a nice case.
And this, of course, as you gathered, folks, this is not a make-up. These are actual facts. These
real,
are things that actually happened. And this is a woman who came through this clinic. You can change the law, or its application at least, by winning hearts. You can slow the machinery of deportation. One of the reasons why it is taking so long for judges to reach decisions denying asylum is that there are so many applications for asylum in the system. I don't celebrate a system that is crushed under the weight of 1.5 million pending cases. But I'm also not going to, I'm not going to cry crocodile tears over a system that slows the movement of if it slows down the machinery, the conveyor belt that leads to a bank of rotating knives. I do care about folks staying safe, and I don't care so much about why they die, if they die. And we are giving refugees a voice. This is an opportunity for someone who may scarcely read their own language, let alone English, to tell their story in a way that is compelling, coherent, and artfully presented in a way that just might be construed as a viable application for asylum. And then occasionally, folks who come through this clinic win. They are welcome.
Paul, I'd like to tell you that I would say quite a few of the people who came through the clinic and who we referred to pro bono lawyers because their stories were so compelling, have won the cases. and they are now in the process of getting their residency, or, they're in different steps of the process.
Right.
So
Yeah.
it can
And
be
then there
bad.
is, and then there is the other thing, the more time you spend in the country, you might end up getting your permanent residence through other means, like a lady that I helped, like it was, I don't know, 2017 or 28 or before, and then she got married, and she's a very good example of that ground that you said, Guatemalan lady that cannot leave their marriage that is being abused. And now she's getting her residence because she married a U.S. citizen, and then she's going to file. Her pro bono attorney is going to file with the court to administrative closure, and that helps. And then I also wanted to tell you about. We've been talking a lot about the Central Americans, but now there are like about 40,000 Afghan people that were airlifted to this country, and they only have humanitarian parole, which doesn't give them permanent status. And we met last Friday. We met a very nice lady with 3 little children, and she's one of them. And she's a lawyer, but she's in this thing, and she was really worried about deportation. And then I went through the motions of that, keeping families safe as long as possible. And I told her, well, don't worry too much about deportation, because first, humanitarian parole gives you 2 years. Then if you file asylum, then it gives you at least 6 months, because the government said that for the Afghans, you have they're going to adjudicate cases in 6 months. Well, yeah. The government lies all the time. So, but anyway, 6 months. And then if they deny your asylum, you're still in the country for up to 2 years or 2.5 years, and you can file again. And then if you're denied, then the case is referred to the immigration court, and then it goes into the one more of the 1.5 million cases. And so I was telling her, and it ended up with like 10 years of safely being in the country with work permit and everything before even an asylum claim was adjudicated. And so kind of she realized some of it, because she doesn't speak English that well. She speaks Farsi, but she understood some of it, and then she calmed down a little bit. The only problem is that her husband is stuck in Dubai, but that's another story. Anyway, so it's real, this thing of staying in the country just because you're in the process, and some of the stuff that we have to tell these people is that kind of thing to allay their fears that they're going to be returned to the country to their death.
Yeah. Well, this slide, the title at the bottom, homage to Parker Wilson. I will, had I not used up all our time and then some, I would have, I had planned to read a longer description, but I'll suffice it to say that Parker Wilson, the attorney around whom the agency Proyecto Adelante formed, sort of a stone soup story where he was willing to help folks out, and a group of volunteers gathered around to provide him interpreters, and and it grew into this little flea bit agency I worked for a spell. But Parker was worked for 6 days a week. Without drawing a salary. He was retired from Sears, and he just did Central American asylum claims back in the years, the 1980s. And I ran into him as a recent graduate from law school, and I worked with him as we presented one application for asylum after another for folks who had fled the Civil War, wars in Central America. And Parker had won, heaven forbid, I think his grant rate for asylum claims was maybe 5%. It was crazy low. And yet he kept at it. 6 days a week, never drew a paycheck. And so over the course of, I guess it was 12 years, he lost a gazillion cases and appealed them all. And then there came a settlement agreement. The good guys sued immigration for systematically denying applications for asylum filed by Central Americans. Turns out that, and it was patently true that the U.S. was denying virtually every application for asylum filed by someone fleeing a right-wing dictatorship, and was denying asylum. It was granting asylum to virtually every ballerina fleeing Soviet Union or Cuba. And so with this huge discrepancy and clear evidence that it violated U.S. law, the Justice Department in 1990 had thrown up its hands and said, all right, all these asylum adjudications over the past decade, throw them out. They're no good. No, we agree. We're going to agree to invalidate all these asylum applications, all these decisions, and give folks a fresh start. Well, Parker's clients, those literally thousands of lost cases, the vast majority of them now are either permanent residents or citizens. I run into them all the time. I mean, I should say that, every couple of months I'll run into somebody who was a former client of Proyecto Adelante, and they're petitioning for family members because their status is fixed. Parker won. Parker ultimately, he didn't, and basically in his lifetime, he never really quite knew how much he'd won. But he had a huge impact. And he was from him that I learned that expression. Sometimes you win by losing slowly. Yes, so that's what for many participants. This is practically the best we hope for. For others, there is the very real hope of prevailing, and that's my pitch. I hope that y'all. I hope that you find meaning in this work and that you stick with it, as I have. The fire in my belly is about as hot as it ever was. These are good folk. They're really good folk, and I wish I could spare more time from my office to have a more active role. Maybe that'll come about again.
In the meantime, we're taking the reins, and hopefully all you volunteers will continue to help, because this is really, really worthwhile. When I started doing this, it changed my life completely. I haven't stopped since then. And it's just incredible being able to help someone else and just having that interaction with a family, or with one asylum seeker or two, or an entire family. It's just incredible. So I hope you continue with us.
Count on it, Anna. I just want to say that, yes, what Anna has said is absolutely true. One of the wonderful things about the work that you do in this clinic is that you're going to encounter angels in your number and among the people whom you help. These are it's a blessed space. I'm not the least bit religious, and this is a blessed space.
Okay, well, thank you for hanging on with us for like 2 hours or more than 2 hours. So,
2 hours, yeah.
I made it so. What do you mean?
Well, no, Paul is very entertaining.
No, it was great.
And so we'll get in touch with you. We have your number, or your email at least, and so we're gonna get the clinic is ramping up, and don't worry if we don't touch base with you like tomorrow, but we'll get you in the loop if you want to continue and help with this endeavor. Thank you.
And if you have any
Thank you.
questions, any specific questions concerning anything about the presentation, you can always email Andres or me, okay?
All right, well, thank you. Anybody wants to say anything? Last chance.
Thank you. It was very helpful.
Miriam, thank you. I'm so glad to see that you're engaged in this.
She's already doing an application. She's
I'm-
already.
you are just
in
unstoppable.
Yes, I wish to have this information like in a summary where I can, when I'm doing the application, I can go back and review. Is there any way to have some of these points, the main things that you said?
Oh yeah, we're going to distribute the presentation. Paul